Most families, when they come to me to ask about guardianship, it's because they've been advised by a teacher or heard through their readings that guardianship is something they need to get for the disabled child when they turn 18. I see my role as helping them to walk through some of the options that they have and not just look at guardianship. I see guardianship as the most intrusive option that we have, and we should use it only when we have to. Not opposed to guardianship. I get it all the time for people who need it. I'm guardian for my 2 first cousins who are severely disabled because they need it. But I see my role as walking through some of the options with them and trying to help them make a decision as to whether or not it's what they need. In the end, they live with the child. They know the child's skills and abilities as well as their disabilities. So I leave the decision up to them. But I do make sure when they leave the office that they have a good idea of the pros and cons of guardianship. I truly believe educators in particular don't know any of the alternatives to guardianship or are not familiar with them. I think all of them just assume either the parent is guardian or the child's independent and they can go to the child for decisions. And if the child is incapable of giving consent on different issues, they're really concerned because they feel like under confidentiality, what do we do? There isn't a person in charge. So I know from my own experience, I have a daughter who's 45, and years ago, we had a wonderful school social worker. He's one of the best social workers I ever had the pleasure of working with. But he was adamant that I had to get a guardianship for Jennifer. And I'm trying to explain to him that I thought a power of attorney would be just fine. And a guardianship wasn't necessary. So she can't sign a power of attorney. She's the R word. And it's like, no, she can do quite well. And she's 45 years old now. We do not have guardianship for her. We've refreshed the powers of attorney so they always stay fresh and current. And we've gotten by just fine for 20 plus years with a power of attorney. There are a number of options to guardianship, and I think you use whatever options you need at the time. And one individual may have 2 or 3 options available that they're using. For example, I mentioned power of attorney earlier for my daughter. We have a power of attorney for her. And this is simply a piece of paper that she signs that she allows us to help her with decisions. It takes no rights away from her. She still has, we don't have veto power. She could say, take a hike, Mom, I want to do what I want to do, and you go away. She's never done that. She's not oppositional, and that's one of the things I would look at as a child, as an individual oppositional. And if they're not, a power of attorney might work quite well if they're capable of giving consent. And by that, the level of consent that she needs is not the same level of consent that she would need for open heart surgery. It's basically saying, if I sign this piece of paper, I'm letting my mom and dad butt into my life and I'm cool with that. So if she has that level of capacity, she can sign a power of attorney. In addition to a power of attorney, I'm Jennifer's representative payee for her Social Security, so there's no way that she would be exploited of her money each month. She works part-time. She's worked part-time for 18 years, and her money, her paycheck is direct deposited into her checking account. And again, I have control of her checking account. She's not a signator on her account. If she was capable of signing her own checks, and many individuals with disabilities are, I would probably want to have a checking account that required 2 signatures, just to be sure that somebody didn't exploit her from writing a check and giving it to them with some sort of sob story or whatever. She's not capable. For her, I need to handle all of her money. It's just not one of her skill levels. She's got lots of skills. That's not one of them. But so you'd look at the individual and see what protections they need. Obviously, a trust is probably one of the best alternatives to guardianship that you can find. Many, many people, their major concern is money. They're afraid their child will be exploited and taken advantage of financially. So if you leave the child's inheritance when the parents pass away into a trust, specifically a supplemental needs trust or a special needs trust that isn't available to the government, it retains the child's eligibility for government benefits as well as gives them a level of control, the parent a level of control, a family member a level of control of protecting the money. Then you've got the best of both worlds. The child, I keep saying child, that's the mom in me. You have to, Jenny's 45, she's still my child. She'd quickly say, I'm a grown woman. But anyway, the individual with a disability would still get all of their government benefits, and this trust fund would be set up to hold whatever inheritance or gifts that they might get from relatives. And then that trust fund can be doled out to purchase goods and services on their behalf. And the trustee can be a sibling, it can be an aunt or an uncle, It could be a nonprofit agency or a professional, depending upon how much is in the trust, of course. You could have a bank, a typical bank could be the trustee, but I would only recommend that for very large trusts. But for your typical trust, a family member is just fine. So powers of attorney, trusts, checking accounts with double signatures that requires 2 signatures. Dealing with a bank like a credit union or a smaller bank that knows your child. I had an incident just recently where one of my clients relayed a story to me where their son, who has Down syndrome, does all his own banking. He's very efficient at paying his bills. He has a help of a care manager who assists him, but for the most part, he handles all of his financial needs, and his Social Security check is direct deposited, and he pays his bills. And his parents were taking them home with him for a couple of weeks, so he went into the bank and made a fairly large withdrawal of $300. And the bank manager followed him out of the bank to see whose car he was getting into. Now, so dealing with a small bank is an alternative to guardianship. It sounds weird, but those natural supports sometimes are far more effective and lasting. So I would just say take a look at some of the common sense things that we do every day and see how they could work in protecting your child. Jennifer, as I say, is 45. We've had powers of attorney for her since she was 18 years old. She, on a day-to-day basis, she handles herself quite well. She gets herself off to work every morning. She does live with a caregiver. It's in a shared living arrangement. She has a home that my husband and I have bought, and she lives in the home, and she gets DDS dollars to support her there. And she's done quite nicely without a power of attorney, without a guardianship, rather. She has just the power of attorney, and that's been efficient. As I said, I've got the other protections in place as well with the rep payee and direct deposit of her paycheck into a checking account that she cannot be exploited from. So I think in her case, at a 45-year-old woman living independently in the community, her needs have been met, and she's very independent, very, very quick to tell you what her wishes are and her choices are. And so we've been able to keep guardianship out of her life, and it's not been an issue. I have a number of clients. I mean, it's just so many. My preference always when a client comes in the door, and this is shooting myself in the foot, by the way, powers of attorney cost a few $100s. Guardianship costs closer to $2,000. Obviously, if you come in my door, I'm a lot better off if you choose guardianship. But I always work hard and tell people my biases up front is to try to be as least intrusive in this individual's life as I can be, and take away as few rights as I need to protect them. And I always, my bias is towards powers of attorney, trusts, checking accounts that have protections in them, etc. I think Massachusetts schools could do a lot more in the area of looking at some of the alternatives to guardianships than what they are now. Part of it, though, comes into educating teachers as to what the options are, and educating school social workers as to what the options are, because these are the people who are in the front line that the parents see. And if the parent has only been told about guardianship, it's an either or. That's the situation. Most people are afraid of the or. They're afraid not to have a guardianship, often because of the financial, as I mentioned earlier, financial concerns. But I think if schools had a list, a checklist to give to parents, perhaps when the child turns 16, when the student turns 16, there's a good chance to look at it. And one of the things that I think schools should be doing is developing goals and objectives in the IEP that by the time Mary is 17 or 18 or whatever, she will understand what it means to sign a power of attorney. And she will understand the loss of privacy rights that will occur if she signs a power of attorney. And I think that's an important way to put it in terms of loss of privacy rights, because a lot of children wouldn't mind, a lot of students wouldn't mind that their parents have access to their records. They wouldn't want everyone in the world to have access to their records, but they're cool with their brother or sister or their parents having access to the records if they know then my parent or sister can be at the IEP meetings and help me out and get the services I need. And I think that's how it should be approached, that a guardian is like having an advocate. An agent under a power of attorney is like having an advocate, as is a guardian. Your perfect ideal guardian is a strong advocate for the protected person, which is the new term that's used in Massachusetts now. It used to be called ward. But I think a power of attorney can be just as strong an advocate without taking away that person's rights. And people need to understand that when you get a guardianship, there is a loss of some rights. It's a transfer from the individual with a disability to hopefully a benevolent, well-meaning, well-intended guardian. It's not always the case. Sometimes you get a very controlling situation or a parent who's so afraid of their child being hurt, they love them to death. So that's another problem. But I think schools, getting back to your questions about schools and what they can do, is to let parents know what the alternatives are. And I always suggest to parents who are on the fence, why not start with the least intrusive? You can start with the power of attorney and then work your way up towards a guardianship. And I tell parents, you've got powers of attorney, you've got guardian of medical purposes only, you can get a limited guardian of the person for only certain areas. You don't have to get a plenary guardian, which is total guardianship. And certainly for the financial, there's no reason for a family to have to get a financial guardian, which is the most expensive and the most intrusive if they do a trust. A trust is such an economical way of protecting the child without having to go to court every year for accountings. It's very expensive, very intrusive to have a guardianship of the estate. So while in some instances a guardian of the person is needed, it's not always the case that a guardian of the estate is, and that could easily be avoided. But I think the schools could have a simple 2 or 3 page checklist. We put out a publication, which I'll give you at the end of this interview, on coming of age. And in that pamphlet, we have all the alternatives to guardianship. So it's certainly something schools could pass out. I mean, I certainly wouldn't have any objection to their using our materials. And to that end, I also do some training along those lines. I go out to parent groups and to schools in the area. It's funny though, it's usually private schools who have me come in, and very seldom do public schools give me a call to speak to the parent groups. It's usually private schools. The private schools seem to do a little better job of that than the public schools do, and I don't know why. I offer a number of trainings for schools and for both professionals as a part of teacher in-service training, for teachers, guidance counselors, social workers, vocational counselors, people who are job coaches working in the field, on how work affects Social Security and other Medicaid benefits that the disabled adult individual needs to be cognizant of when they graduate from high school. These are important benefits. I always tell people if you don't have Medicaid, which in Massachusetts is referred to as Mass Health, you're in deep trouble because that's the ticket to services. No Mass Health, no services. So understanding government benefits is something I do all the time for professionals. I like to give those same presentation to families. So if they have parent support meetings or PAC meetings, I'm always available to come in. I tend to be booked about 5 to 6 months in advance just because I don't charge a fee for any parent trainings or nonprofit agencies. So a lot of people call me, but you can't get me if you don't call and get on the schedule. And so I would say trainings on government benefits is important. Obviously, trainings on guardianship and less intrusive alternatives to guardianship. And then in addition to that, I think it's very important that parents of adult children need to understand how work affects SSI and SSDI and what the rules are, because you don't want to, with all good intent, place your child in a job that puts them in a worse off position that results in their losing benefits that are critical to their lifetime care. So I think it's important to know that interplay of how work affects SSI and SSDI and how it affects Medicaid and Medicare. Those are all very important details. So in addition to the guardianship training, where I go in all the time, I have a guardianship training that's called Guardianship and Less Intrusive Alternatives to Guardianship. It's an hour to an hour and a half presentation. But I usually suggest to schools, if I'm coming in to talk about guardianship, that we try to have at least a half an hour to 45 minutes on government benefits and how work affects those government benefits, because I think those are 2 key topics for families.